Everybody, it's Matt Scudera with the Credit Research Foundation. It is great to have you with us. Great to have this particular topic on this micro learning session for us, which is on receivership. A topic that has come to us not only through our research committee, but through a number of members, and certainly a topic that seems to be very relevant in this time of COVID and the wave of debt that we see coming, bad debt coming, and activity through the courts, bankruptcy courts, and whether that's in court or out of court. And boy, is it wonderful to have Justin Kesselman with us with Arent Fox. Justin is an associate with the firm, and as you may or may not know, Arent Fox is a friend of the foundation and a constant contributor of content along all fronts, whether that be webcasts, webinars, articles, in-person forums, and as you probably know, has recently written a book on secured transactions for us, which we are greatly appreciative of. And Justin, greatly appreciative of your time. I know you have a busy schedule, and we are appreciative of the time that you're sharing with us today. So we're going to kick off today's session. Again, Arent Fox, a friend of the foundation, some detail about them there. And additionally, a friend of the foundation, as we said, and some additional detail here. Justin, why don't I pass the baton off to you? And I know you got a lot of content to run through with us today.
Absolutely. So thanks very much. And thank you to the Credit Research Foundation for putting on this program and for inviting Arent Fox to participate. As mentioned, with the subject of the program will be receiverships. So I'll give a general overview and some of the differences between receiverships and bankruptcy case that might be a little more familiar to some, and then provide some of the strategies and practical tips for dealing with the company in receivership, and then conclude with a brief introduction to another insolvency procedure you may come across, which is the assignment for the benefit of creditors. So we can get started with the first slide. So receivership is a judicial proceeding to deal with the debtor-creditor relationship. Typically an insolvent situation in which a business or particular assets are placed in the custody and control of a court-appointed neutral party. And that person is referred to as the receiver. Similar to what you would see as far as a trustee in a bankruptcy case, but as we'll discuss, there are some key differences to understanding the scope of authority and the sources of that. But a receivership is often considered an alternative to bankruptcy, although receivers may be appointed in a number of different circumstances outside of the insolvency and liquidation scenario. It includes winding down and liquidating a business. That's generally referred to as a general receivership or an equity receivership. But it can be more limited to managing and liquidating particular parcels of real property, commercial property, compelling compliance with court orders, or preserving assets for investors during an SEC enforcement action. You'll hear reference to an SEC receivership. The breadth of the receiver's duties and authority are going to depend on the reason for the appointment, some of those purposes just discussed and listed on the slide, and also the applicable law governing that appointment. So that can derive from state law, statutes, federal statute, the federal receivership law, and also common law, case law that's developed over time in the state and federal courts. We can go to the next slide. So generally speaking, the receiver is going to be appointed according to a court order, prompted by a request made by a creditor, governmental agency, or an interested party. Typically, you're not going to see a standalone action for a receivership. It's going to be in the context of some other debtor-creditor dispute. A secured lender who's trying to get control of collateral, who might view a receivership as the best way to take control of that collateral, or a lawsuit in which a creditor is seeking to enforce judgment remedies by appointing a receiver over the entity, and they'll have to make a showing to the court and convince the court that this remedy, often referred to as a drastic remedy, taking control away from the business owners and giving it to a third party is warranted. Now, once that showing is met, the court will enter a receivership order, And the receivership order is really the key document that everyone needs to see and understand in order to get a sense of the roadmap of what's going to happen during the receivership. The receivership order should set out the parameters of the receiver's powers and obligations, notice requirements for the case, key dates, the process for submitting claims to the receiver. And all of that happens within the parameters of whatever the applicable law is, if it's in a state court or federal court. And so, unlike a bankruptcy case, as we'll discuss, it's a lot more nuanced from jurisdiction to jurisdiction. There's not necessarily one governing law that's going to cover, no matter, any receivership, regardless of where it occurs. The receiver is going to be answerable to the court and will be filing periodic reports describing the operations, collections, and expenses. Early on in the case, the receiver will take an inventory of the various assets, schedule those assets, try to get information from the debtor's management or owners about existing liabilities. Then they'll file those schedules of assets and liabilities with the court. The receiver, if the receiver is going to be stepping in to take over a business, the receiver will generally have the ability to operate that business. Unlike what you typically see with a Chapter 7 trustee, where the trustee is going to move in and generally shut the business down and just get straight to liquidation. An equity receivership is going to be a little more flexible. There might be a benefit to the receiver continuing on the business, perhaps keeping on particular employees and taking steps to maximize the recoveries. And once the receiver steps out of that box of ordinary operations and tries to liquidate assets, take actions outside the ordinary course of business, they'll have authority to do so, but usually only upon going to the court first. So they might get a buyer for the business or buyer for particular property, and file a motion with the court to get approval. Move to the next slide, please. You can move to the next slide. So as I was just mentioning, there are some distinctions between a bankruptcy case and a receivership. The lack of uniformity is one of them. Another one is the differences in restrictions and technical requirements that govern the proceeding. Bankruptcy proceedings are extremely complex, due in large part to an extensive set of statutes, federal rules, local rules, individual judges' rules, all intermeshed, and it can be very difficult to navigate. And although some states have fairly comprehensive receivership statutes, a lot of times the vast majority of what's going to govern the proceeding is the context of the receivership order, which is going to be substantially less detailed, and it's going to give more flexibility to the receiver in what the receiver is doing, right? Another key difference is that a bankruptcy proceeding is overseen by a bankruptcy judge, often with a separate watchdog, like a trustee, the United States Trustee's Office, all who are spending all of their time, all the time, governing the debtor-creditor relationship, overseeing restructurings, overseeing liquidations. In contrast, in a receivership, the case will often be assigned to a state court or federal court judge who has your civil litigation, criminal litigation, and dealing with receivership proceedings is often a very small part of their docket. So it's not necessarily in that judge's wheelhouse, it might be, but there's an opportunity for more deference to the receiver, particularly in the absence of vocal creditors, right? So, as we'll discuss in a little more detail when we're getting into strategies, right? Understanding the context in which this proceeding is happening should really inform the actions you take during the case, because getting involved and getting involved early might be critical to preserving your rights down the line. Yeah, another component that's different, the transparency, is that federal bankruptcy proceedings are very public. It's all online via PACER. Everyone can get access. The state to state, the access to online dockets might be more limited. So there might be a little less access to see what's going on. So again, should prompt creditors to find out who's in charge, ask questions, and get the information they need to make important decisions. Another key difference is the limitations on jurisdiction. A bankruptcy court, wherever it's located in the United States, is going to have nationwide jurisdiction, to the extent allowed under the federal jurisdiction statutes, which is pretty broad. In contrast, a state receivership court is going to be limited to dealing with a property that's within that state court's jurisdiction, might not be able to assert personal jurisdiction over out-of-state parties. And so that also will inform some of the decisions made and how you react to finding out that a receivership's been filed. And finally, typically this is going to be a liquidation. There are some exceptions, but with exception, there are going to be very few reorganization type receiverships. Even though the receiver is getting involved and can operate the business, the goal is to bring this thing to wind up the company and get value out to the key constituencies. You can move to the next slide, please. So there are some more specific comparisons to bankruptcy that creditors should take note of. The first thought when creditors who are have come up against insolvent companies or companies in bankruptcy, the first thought people think of and certainly should think of is the automatic stay, because on the filing of a bankruptcy case, collection attempts have to stop, right? And people know that, and you're wise to respect that. That may happen in a receivership, but again, it's going to vary from jurisdiction to jurisdiction. So again, that goes into the critical understanding of what's in the receivership order and what does the particular state law provide. One key element of this, right, is set-off rights, and that is a subject of interest that creditors are interested in right now. That is the subject of another program that's being put on through CRF. But the automatic stay generally does stay set-off rights under state law. A receivership order, on the other hand, may not. So if a receivership has been filed, right, and you think, well, I know in bankruptcy, my set-off rights are cut off, not necessarily in a receivership. So if the receivership has been filed, you need to find out if the set-off rights are in fact cut off by the receivership order or the applicable state law. And if not, it might be wise to take action quickly to exercise those rights. Also, the estate fiduciary's powers are often going to be different. What the trustee in a bankruptcy case is able to do, as opposed to what a receiver can do in a receivership proceeding. The free and clear sale was the first thing that came to mind for me. Typically a receiver will not have the ability to sell property free and clear of liens the way a trustee could, although there are some state laws that do allow that. Also, avoidance of preferences. A bankruptcy trustee can avoid preferential transfers made to creditors in the 90 days prior to the case. That may not be available under applicable state law. And finally, the involuntary nature of a receivership. Although you can push a debtor into bankruptcy under the bankruptcy code, there are there are technical requirements for doing so, and there are consequences, and potentially very stiff consequences, if that bid fails. Right? You could be responsible for attorney's fees and potentially punitive damages if you file an unsuccessful involuntary bankruptcy petition. If you're trying to force a debtor into an insolvency mechanism. In contrast, a receivership, if you want to force a debtor into an insolvency mechanism, might be a better option, because even a failed attempt to do so is usually not going to bring the same type of stiff sanctions that a failure to force an involuntary bankruptcy would. You can move to the next slide. So some of the trends we're seeing right now in receiverships across the country are, when is a receivership the best option when bankruptcy is not otherwise available? And that we're seeing in the cannabis space, because cannabis businesses, whether you're in the growing space, the selling space, bankruptcy is unavailable to you. And this is important for not only for potential debtors to understand, but creditors to understand as well, right? Can't force a cannabis business into an involuntary bankruptcy case, right? So receivership might be a better option, right? And also understanding your rights if a cannabis business does enter bankruptcy, right? That you might have ways to force them out of bankruptcy if it's advantageous to the creditor, because there have been a number of cases on this issue that across the country that have removed debtors from Chapter 7, Chapter 11, Chapter 13, even if their business is in the marijuana business, because it is still legal under federal law. We've also seen revisions to state receivership laws, in response to COVID, and also in response to cannabis, I should say, but also in response to the COVID public health crisis, and trying to make additional options available for struggling businesses. One in Rhode Island is very similar to the small business reorganization cases under subchapter 5. They've adopted a non-liquidating receivership program for small businesses in Rhode Island to help deal with the COVID crisis. And also some states, including Florida, have enacted the Uniform Commercial Real Estate Receivership Act, which allows free and clear sales similar to Section 363 of the Bankruptcy Code. So again, goes to the importance of understanding what the particular rules are in the state where the receivership was filed. Federal receiverships have been on a downward trend as of late, but there could be changes to that in the coming years for a number of reasons: change of administration and the sunsetting of the higher dollar threshold for getting into the Small Business Reorganization Act. Move to the next slide. So strategies for creditors. What do you do when you find out that there's been a receivership for a debtor party? Well, the first thing is the receivership order will generally require notice to creditors, right? But given the involuntary kind of nature of the proceeding, the receiver comes in, right, a neutral party with no real knowledge of this business, and might have limited information about the identity, contact information about creditors than you would see in a voluntary bankruptcy filing, where it's the ownership or the management that's putting the debtor into the bankruptcy. So if you learn about the receivership indirectly, first steps: identify the receiver, identify the receivership court, get a hold of the receivership order, and contact the receiver to provide your contact information, amount you are owed, get the basics down so you're not left behind going forward. Once you have that receivership order, review it in detail, calendar the key dates, look for the deadline for the receiver to file schedules of assets and liabilities and other reports, the deadline and details for submitting claims, any court dates that might be scheduled. That's just the baseline for getting started. Move to the next slide, please. The next step would be, and this has to happen fairly quickly, evaluate whether a bankruptcy case might be more beneficial, right? And I know I said some scary things about filing an involuntary petition, but the thing about once the receivership has been filed, right, is that one of the elements for commencing an involuntary bankruptcy case is met, right? Typically, without the receivership, you'd have to show that the debtor is not paying its dues, its debts generally as they come due. That can be difficult, right, for a single creditor to know. But once the receivership is filed, that filing of the receivership satisfies that element automatically. So that puts you one step ahead of the game. The next thing to do is consider the fact that after the 120 days after the receiver's appointment, the Bankruptcy Code provides greater protections to the receiver. So at the beginning of the receivership, the receiver is going to take hold of all the assets of the business, right? And that first 120 days is a tenuous grasp on those assets. After the 120-day mark, the bankruptcy code makes it very difficult for a bankruptcy trustee, if appointed, to claw those assets back. So that 120-day window after a receiver is appointed is really critical for those two reasons. The additional step to take at the beginning is understand the applicable law. We talked about some of the different laws that were passed just in the last year, right? The laws are always evolving depending on the particular state. And it might happen more quickly, particularly with case law, than you have with evolutions of the bankruptcy code, which do not happen that frequently. So if the receiver is a state law receiver, that typically that receiver may only have jurisdiction over the assets within the particular state that the appointing court has jurisdiction. So if a creditor has a chance to pursue a collection strategy against assets that are outside of the jurisdiction of the receiver and the receivership court, that's something to consider. Can you move quickly, right, and get at an asset that's not subject to the receiver? Because the receiver will be looking to benefit all creditors, and a particular creditor is only, concerned about when do I get paid and how do I make that happen as quickly as possible. Stay active, involved, and informed, right? As noted, the absent objections or creditor involvement, the judge may not be inclined to question the receiver's reports and requests. Again, small part of the docket, particularly in a state proceeding. File your claim, evaluate proposed asset sales, and provide the receiver with additional information if you think doing so is advantageous. Move to the next slide. Another thing to do is create a checklist, right? And to the things that should happen. You identify the receiver, right? You identify the receivership court. Ensure that you are on the notice list. Review the receivership order. Create a calendaring system. Understand the governing law. Evaluate the bankruptcy case. File your claim and review all the asset and liability schedules. And identify those other sources of recovery. And by kind of operationalizing these steps and making sure that you're checking each box, you're putting yourself in the best position to have a positive recovery and get the most out of the receivership as possible. Move to the next slide. Okay, so the final topic here is the assignment for the benefit of creditors. Now, this is a program on receivership. So why am I bringing this up? Because these two options in particular, state law options, are frequently considered side by side. When you hear talk of a receivership or potentially pushing an entity into receivership, assignment for the benefit of creditors is right there with it, and it may come up. And it's important for everyone to understand this tool as well. So I just want to give a brief overview of what an assignment for the benefit of creditors is. Typically, often referred to as an ABC, just in casual parlance. So you hear, maybe an ABC is a good idea for this particular debtor. They're referring to an assignment for the benefit of creditors. Now, whereas a receivership happens by a court order, right? In the first instance, going into court and saying, Judge, I need you to give me this equitable remedy, right? An ABC is going to originate through a contract, right? You're going to go to the debtor is going to come to you and say, let's do a workout of sorts, right? Through an ABC mechanism. And how does it work? Similar to a receivership, all of the debtor's assets, rights, everything are transferred to a third-party fiduciary known as the assignee. The assignee acts as a trustee for the benefit of creditors, collects the debtor's assets, and distributes them according to a predetermined priority scheme, established either by statute or the assignment contract. The procedural aspects of an ABC are going to depend, again, on the particular state, right? Some states do have limited court involvement. You don't necessarily need the court to commence the ABC, but once you do commence it and you file the ABC paperwork is filed, usually in like a state clerk's office or the clerk of court, there is some court mechanism is put into place that provides usually a limited oversight, right? schedules of assets and liabilities have to be filed. There has to be reporting, so the court can oversee and make sure that there's a process being put into place. So creditors are being given notice and given an opportunity to be heard. In some states, just Massachusetts, there's really no formal court involvement or oversight, right? This is an out-of-court procedure. A party can go to court and complain about something or ask for relief if they're so inclined, just like in any other litigation atmosphere. But the crux of it will be out of court. This provides less transparency oftentimes, but it also provides some advantages: less cost, less process, right? So it depends on the situation, but an ABC can be a great result if creditors are confident in the assignee that's put in and confident with the economic terms of the assignment and hiring the assignee, and can cut out a lot of the costs that come with a court proceeding. So that's another tool that creditors should be aware of alongside the receivership. So I'd like to thank everyone for tuning in today and their interest in this program. If there are any questions, you can certainly contact me or my colleagues at Aaron Fox, and we'd be happy to walk anything through further.
Justin, this is a great session. I want to thank you. I know you have a extremely busy schedule, so I want to thank you for sharing your time with us. I also want to thank the Aaron Fox organization, not only for allowing Justin to spend time with us, but all of their support. As I opened with, they are a friend of the foundation. We're extremely appreciative of all that they do. And this is certainly a fine example of the educational share that they provide to the community. And can't thank you guys enough for that. We're going to close out this session. And again, as Justin said, if you have any questions, the Aaron Fox team contacts are in front of you. Please feel free to reach out to them. I know they are always willing to help. If you need CRF support to get you connected with them, don't hesitate to reach out to us as well, as we'd be more than happy to make that link for you. Other than that, Justin, I want to say thank you again. I hope you stay safe and healthy, and we look forward to seeing you in person sometime at a CRF meeting.
Absolutely. And thank you very much for inviting me.
Have a great day, everybody.
You as well.
Bye-bye.